to warn everyone the space is recorded, so you will be able to listen if you missed our introduction or missed any part of it, or want to obsessively break it down and quote post it. It will be available for you. But just to give you guys a heads up, we're not going to do mics. We have a very limited time with Wes, and so I have prepared and aggregated all the questions from the communities and sent those to us. A little bit different than before. We've got a bunch of questions regarding the Meta MMAT, MMTLP potential lawsuit. So we're going to try and shotgun those. We're going to try and rapid fire those so that we can get through those and give Wes a little bit more time to opine on some much broader issues. So, Wes, are you up for that?
I'm up for that. I looked at all the questions. It looks about like 6 hours worth of answers, but okay. It's,
I know. I've
I don't
actually
know what kind of rapid fire you got in your machine gun, but I'll try to respond to the best of my ability. Say that.
you know what?
I do
And
only
you
have an hour, just to be candid. I got 1 hour. That's it. Okay. So,
Yep. So we're gonna start that off here in
The
just a
time
minute,
is
guys.
6
And
o'clock
actually,
p.m.
100. If you want to come up and do that, I don't actually have it on me right now. Wes 100 is going to read a disclaimer here really quick before we begin, and then
okay.
we'll get
Sure.
started. Yeah, absolutely. Hey, Danny, I sent you a mic. But yeah, guys, I'm going to ask the questions. Wes is going to answer, and we'll get through as many as we can. We've tried to consolidate them as best as possible. So many people had so many questions, and so we'll do the best that we can. And if we leave any holes, we'll have a great reason to invite Wes back. Danny, go ahead, and then we'll get started.
Okay, this space call is for educational and informative purposes. It does not serve as a vehicle of financial or legal advice of any kind. Having said that, the opinions expressed on this call are protected by the First Amendment and the Constitution for the Republic of the United States of America. Any unauthorized recording, manipulation, or tampering of speaker voices via an AI is strictly prohibited. Thank you.
Awesome. Thanks for that. Okay, Wes, let's go. So, Wes, on May 20th, 2024, Metamaterials Inc. released a press release giving an update regarding their investigation into manipulative trading activity in both MMAT and MMTLP. From the PR, quote unquote, the lawyers have now concluded that Meta has a meritorious claim for market manipulation against several parties, end quote. They quoted you. I believe Meta has an actionable case in connection with its MMAT and MMTLP claims. We look forward to working with the company, close quote. Later in the PR, they indicated that they, quote unquote, plan to share these findings with regulatory agencies and that they expect to file legal proceedings in the coming quarters against the responsible financial firms. Just wanted to give a little context to that for people that may not be familiar. So, Wes, let me hit it right from the get go. Have you already begun or have you completed the drafting of Meta's meritorious claims?
We've begun that process. I can't get into the details until it's filed. But yes, we've begun that process, but are in the process of, really selecting what is the best approach. Because as we all know, the main way to do this, we've tried it every other way without litigation. It just doesn't work. Is to ultimately file a claim that is sufficient to beat the 12B motion, which is the motion to dismiss, and then in doing so, get discovery across the board on everything that impacts the shareholders of MMAT, which would include MMTLP, because of the one-to-one, preferred to common issue, as we're all familiar with. So, yes, that's begun. Has it been completed? No, it is not, because we're trying to make some decisions to first to have the best chance of beating the motion to dismiss. It's an enormously complex decision, and frankly, has some guessing associated with it. So,
Okay, Wes, you actually just hinted at what may be our first no comment question, but without giving away any. And guys, I've given him full reign to say no comment if there's something he cannot answer. But without giving away any strategy, Wes, can you provide any insight into specific claims that Meta will be making against some of these potential financial firms? I mean, are we talking naked shorting, spoofing, washing trades, anything, all of the above?
Well, we're certainly talking spoofing. As the community knows, we now have 4 cases in New York. One of those is in the midst. We're almost completed with discovery, which has been, needless to say, an enormous eye opener. Because what you learn in these cases, which everybody knows, I've been doing these for 22, 23 years. Um, Basically, is the bad guys, the defendants, are always a step ahead. They're always thinking of new ways to hide things, to obfuscate things, to send them overseas, to do it through dark pools, to do it, in ways that are make it more difficult for plaintiffs to prosecute a claim. And so, certainly in the Harrington case, which that's been pending for 3 years, and we're now about finished with discovery. We're now kind of up to speed on some of the more current methodologies being used. I can't discuss those because they're subject to a protective order. But essentially, we'll be bringing, at least our intent is to bring 12B5 or 10B5 market manipulation claims and claims under 9A and 9B, which are basically fraud claims. And then, expand it from there. We're going to start with a select group of defendants um, that we have identified, and then ultimately, potentially, there are more defendants to include. But we have to figure out first how to get past the motion to dismiss, to be candid with our best case.
Yeah, and of course, as you do get past that motion to dismiss and potentially into discovery, more and more potential defendants could reveal themselves. And so, but you just spoke about your 22 years of past experience. Do you have an estimate, Wes, on what kind of costs we're talking involved in litigating a case? For Meta that you just outlined. Now, I don't want your flat fee, right? I just, in general, what are we looking at in terms of how much is this case going to
Well,
cost?
you know, it's a good question, and of course, all that depends on what the client's arrangement is. But generally speaking, our model is basically to cover costs, and then the rest we do on a contingency. Just to cover those costs in totality is running about 12 to 13 million dollars a case.
Okay.
So it's large, and I will tell you, in the spoofing context, it's more expensive because of the way that the trades are routed and the way that it goes, cross border, and the way that it both leaves the U.S. and then comes back into the U.S. That takes an enormous amount of effort. So it's hard to estimate with certainty what that cost is. But that's probably on the high side. The more
Probably got a phone call, guys. Give him a minute. Hey, Wes, if you can hear me, we can't hear you.
I
Oh,
said,
there you
that
are.
would cover through trial also.
Okay. So you just you gave the estimated cost of 12 to 14 or 13 million dollars. Do
Well,
you?
that's in a ballpark. I mean, again, this
Yeah,
is this
sure,
is this is a guess, okay? But
sure.
it's a guess based on past history. We did some cases for 6 million in costs, but again, over time, that's gone up because they make it more difficult to find all these things. There's so many different routes and avenues they can go down. So it's just
Yeah.
it takes an enormous effort. I can tell you that it takes an enormous effort.
So, Wes, do you know and can you opine a little bit on whether or not Meta has secured the funds for your costs?
Let's just say that's being handled right now, and that's in process. So
Okay.
the answer would be not 100% secured at this point, but basically, 1 second. Hey, Holly, have them hold my calls, please. Um, Basically, that's one of the pieces that have to be completed to make this go forward. So.
Okay. Are you able to give us any indication? We in the Meta investor community have seen recently and through PRs and filings that appears to be liquidating assets. Do you know if any of that funding has come from the liquidating of assets, or are they potentially seeking a venture capital investment?
This is part of what. Yes, Jennifer. Who? No, I
Uh-oh.
can't talk to her right now. I'm on a space call. Hold my calls, please. That's on my case against Disney. I'm sorry. So
No, no,
anyway,
no. Don't apologize, Wes. We know
we
you're
we,
busy.
we represent the original scriptwriter of Moana. That's a different case. Anyway, so so at the end of the, I'm sorry. What was the question again?
The question was, do you know if recently seen through their filings that they are liquidating assets? They just sold off their nanotech or in the
Right.
process of doing that. And, or, so I was wondering, the community is wondering if that's how they intend to fund this case or if they're potentially seeking venture capital investment.
They're not going to be funding any of it from the company. Let's put it that way.
Okay.
So,
Good.
so let's just say the lawyers and others are going to be procuring the funding. We hope to get this done. So,
Okay. Wes, let's talk about damages. And I know, of course, that, we're not completely into this, but when you do file your case, you do have to assert some sort of damages. In general, how do you and your clients go about determining damages? And do you have an estimated of the potential damages that we're talking in this meta case?
really, you can't estimate with certainty, but I can tell you, unless we thought it was worth at least $100 million in damages, we wouldn't even touch it. I anticipate this to be substantially more, but I don't know. Because ultimately, don't forget, in the even with all the proprietary methods we've developed, even with share and tell data, even with spoofing analysis, even with everything we've done, you can't estimate with certainty the damages because when you peel back that onion, you typically find measurably more, and some of it, is better, some of it's worse, like every case. But we anticipate, it to be larger. We wouldn't be spending this much time on it, but basically on the come. So at the end of the day, I expect it to be, pretty large. And until we get into discovery and chase every defendant and figure out what their role was and how much damage they specifically committed or, what they were responsible for, I can't tell you that. I can tell you that damages typically are associated with the difference between what the company sold shares at versus what they should have been worth, but for the manipulation. And the same would apply to shareholders. Because another thing we're looking at, which again is just in discussion, because we enlarge our team, because we've got many other firms working with us now in this space because of the number of cases we have. We've had to enlarge our bench. We're looking also at possibly doing a class action, and it's separate from the company's claim, a shareholder class action for various reasons. But there's obstacles there too, including arbitration clauses and broker agreements and other things, even though there's some case law in the 11th Circuit that says differently. It depends on, what judge you get and what district you're in. But we're looking at all the above. But in either case, the damage model presently is, and again, there's many different types of damage models, but the best one we believe is the but for price, the difference between what shares were sold at, either as a company out of its treasury or the individuals, versus what they could have been sold at, but for the manipulation. And that manipulation could either be in commissions or it can be in omissions, something that somebody omitted doing or something that somebody intentionally did do, that type of thing.
Okay, great, Wes. Now, are you familiar with the Sorrento Therapeutics case out of a federal bankruptcy court in Texas?
Yes, we're
Okay.
representing Sorrento and its subsidiary right
Okay,
now.
so let
So
me let me ask you a
we've been
question.
representing them for 6 months. So
Okay, so let me ask you a question. Will Meta be seeking any type of injunctive relief like what was done in the Sorrento case where the judge ordered a share count and then ordered the shorts to cover their positions? Will Meta be seeking any sort of injunctive relief in that manner?
Yeah, well, number one, that's really not, no, with no disrespect, that's not an accurate representation of what happened.
Okay.
I don't have it exactly in front of me. The judge, who's no longer on the bench because of alleged impropriety, basically, we're now with a successor federal judge who I've been in front of, who's very good. Um, and the predecessor I thought was good. It's just he's had some, different issues that you can look up and figure out on your own. But at the end of the day, he did order a share count. I don't think he ordered positions to be covered. If he did, I don't remember that in the court orders. Nonetheless, that case was withdrawn and abandoned. And now, as you'll probably know, I'll tell you what's in the public record. I can't share anything else. Um, we moved to get a 2004 examination and seeking documents. We got those from the DTC. We got those from FINRA. Now we're seeking those from the audit, the spun out entity out of FINRA, which is a audit system basically that they have, consolidated audit called CAD. So basically, there's presently a motion pending in that case, and we're fixing to fight over those documents. Sadly, the Security and Exchange Commission has come in and joined the bad guys against us, saying we don't need that information. I'll be arguing that motion probably in the next 30 days in federal court here in Houston. So the injunctive relief that you're discussing, frankly, is very difficult to obtain. And the reason is, in order to get an injunction, you have to prove you have an inadequate remedy at law, which in most cases you could be compensated for by money, other than maybe the disturbance of corporate governance, which we don't believe is a successful argument. You have to show a probability of prevailing on the merits, and you have to prove that it maintains the status quo. Those are difficult predicates to prove in a temporary restraining order, which then ultimately turns into a evidentiary hearing, which is a temporary injunction. And ultimately, though, what does happen in bankruptcy court is you are allowed to seek discovery, and you'll also see in PACER, if any of your listeners go on PACER in that case, the Sorrento case, which also involves Silex, its subsidiary, that basically, uh, uh, if we're successful in getting that information, uh, the post confirmation estate trustee, because the bankruptcy plan was approved, it's done. But the post confirmation estate trustee is the one who now has the ability to bring claims. Well, the good news is for us, they've joined us in our motion to get the documents from CAD, and so ultimately, I'm cautiously optimistic that we should get those documents, even though the SEC and the subsidiary or affiliate of FINRA has said no against us, which just blows my mind. But nonetheless, that's where we are.
Well, and we of course in the MMTLP community are very familiar with their objections and obstruction of providing that data as well. So, Wes, before we talk about the data more specifically, let me ask you a question. In your experience, in your 22 years representing companies and securities cases, when they do settle, first of all, what percentage of your cases settle versus going to judgment? And when they do settle, how often are shareholders receiving proceeds from that settlement or judgment?
Yeah. So I have a list of all of our cases. That in the first several years in New York, we weren't very successful, to be candid. Several of those got dismissed. Some of those resulted in small settlements. The first big settlement we got was Overstock. The next one was the Taser Gun Company. The next one was Pet Quarters, then Eagle Tech, and I could go down the list. But I would generally say in the last 15 years, we've lost one half of one case based on claim preclusion. Some of those settlements have been large. Some of those have been smaller. I can't get into specifics because it's confidential. We signed a confidentiality agreement. Um, So I would say the vast majority of them, a high percentage, settled. None of them have gone to trial. I don't believe any of them will ever go to trial. That's my view, but I could be wrong. Um, and I'm not, what shareholders got, I don't know. In the cases where shareholders were involved alongside the company, each shareholder got their own damage model in the settlement. So just let me be clear about that. We have done cases where we represented shareholders and the company. And in that case, the shareholders got their own settlement because they had their own damage model. And the company got their settlement because they had their own damage model. In cases where we just represented the company, how many of those companies dividended out to shareholders? I have no knowledge of that because after the settlement, I wasn't really representing the client anymore. So I have no idea what happened.
Okay, thanks for that, Wes. Do you know if Meta is open to having shareholders join this potential claim with you?
I don't, but I would suggest that if that were to be the case, would have to be a class action because
Okay.
ultimately, if you get more than 50 plaintiffs, you're subject to a different statute that the bad guys got passed in 1999. So SLUSA, and so ultimately, um, it would have to be a class, which is something we're looking at now, but we haven't signed off on, and that wouldn't just apply to Meta. That would apply to any case we do to
Okay.
essentially cover more damages, basically. But again, as I said, there's issues with class action. You have to get certified as a class. That's a big deal. You don't want to be going to arbitration. You've already seen what's happened to those cases that are in arbitration. It's a FINRA arbitration, and that's pretty much a joke in my mind. So
Okay.
anyway.
So, one more question, Wes. Typically, when settlements do happen in these cases, they are sealed, correct?
It's not sealed. The settlement agreement doesn't get filed with the court. It's a private settlement, and yes, it's subject to a confidentiality agreement.
Okay.
Rarely are some of that exposed. I think one piece in Overstock was 20 million that got exposed. Another piece in Overstock, and because we had two cases there, maybe 10 or 15 million of it got it exposed. The rest of them have been confidential, and so you know, my answer is assume it's going to be confidential and it's not going to be disclosed is the answer.
Okay. Are those monies disclosed in tax filings
Uh,
that
I
you
don't
know of?
know.
I know you're not a tax attorney.
I don't know.
Okay.
I'm not
Obviously, we
auditing
want to know
tax
what the money
returns.
is, Wes, but
Well,
no,
I
I
don't.
appreciate that you
I have
don't
a
know.
hard enough job doing this part. So,
Okay. Well, let's talk. Let's drill down more specifically into the data, Wes. So last June, June of 2023, Meta Materials released a PR announcing that they had retained, of course, your firm as well as Warshaw Bernstein
yeah,
and Shareholder Intelligence Services, who we know as Share Intel,
yeah.
to ascertain whether, based on the data, that there was potential legal claims. So, just want to make sure that everyone understands that as well. So, let me rapid fire some of these questions. You once called the short positions in Meta Materials stock, which includes MMAT and MMTLP, the mother lode of all naked shorts. Were
Yes.
the numbers collected what you anticipated? And is Meta still the mother lode of all naked shorts, or have they showed up and someone else taken the crown?
I can't get into competing cases because there probably are one or two cases, one of which we're fixing to bring and one of which is already there that's substantially larger. But it is still, in my opinion, but again, I want to be clear, that's still my gut opinion. As I've stated, until you get into discovery, you don't know, what you have. But my gut is, if you as my dad used to say, you put a gun in your mouth, what's the answer? Is it's still very large and a substantially larger than the vast majority of our prior cases. I'll put it that way. That's my gut, but
Okay.
again, qualified opinion that we got to get into discovery and figure it out first.
Okay. Wes, was Share Intel able to collect data not just for MMAT, but also specific to MMTLP?
Absolutely not. There was nothing at the DTC about it. Broadridge didn't have anything about it. The only way we were able to collect MMTLP data, and I can't really get into specifics, is to do it through some clients that had very large positions, and figure it out that way with respect to certain companies, certain brokers. But I can't really disclose any of that. So we did it, as I would say, the country boy way on the MMTLP side, because every avenue we went down, with Flamethrower and others that we tried to help, basically nobody helped us. In fact, FINRA fought us, DTC fought us, brokerage firms wouldn't disclose anything until ultimately we sent some very large clients in to find out some data, and that revealed some things, but I can't get into that.
Okay.
Uh, but let's just say, and as you know, I've also talked to some people in the community that have given me some data, which I'm very grateful for. So that piece doesn't have the certainty that the meta piece does. But remember, for every piece of shareholder of meta that came from Torchlight, ultimately, yeah, I think it was about 25% of the company were Torchlight shareholders in the merger, something like that. Don't forget, for every share of stock of Meta, they got one share of preferred. So I forget what that number is, but it's, I think, what, 165 million shares or something. I
Yeah, we're
forget.
supposed to be 165.5, but we, of course, believe that shorts were never closed out of Torch, and so those would
Oh,
have been
that's
moved into
well,
Meta as
that's
well.
right. That's right. That's my gut too. And
Yeah.
and we do have some preliminary information to indicate that on the meta side. But the bottom line is the MMTLP, as you know, is so convoluted based on
Hmm.
what FINRA did and what everybody else did. You're not really going to know until you get into discovery, in my view. Although my gut is that's going to be even larger than the meta piece. That's my gut. Okay.
Okay.
So anyway,
So, Wes, is Share Intel continuing to monitor the trading data for
yes,
Meta?
yes, they are.
Okay. And you're
Meta
receiving
is still
regular reports on that.
paying share Intel. Yeah,
Wes, do you by any chance recall when exactly it was that your firm and Warshaw Bernstein concluded their assessment initially that Meta really did have meritorious claims for market manipulation? Do you remember about when that was?
I don't. I've got so many cases in my head. I
Okay.
don't know, but I know it wasn't terribly long ago.
I mean, was it 6 months ago?
I would say around 6 months ago, or maybe
Okay.
even soon, maybe even 4 months ago. But somewhere in there, three to 6 months ago would be an estimate without
Okay.
nailing it down to a date. You know.
Okay. Wes, do you have from the data that you've collected, do you have a sense of how many long and short positions are held in MMAT at the time of your last report? I know you probably can't disclose it,
I can't.
but
I
do you
can't.
have a
I
sense?
can't tell you that. That'll be in our
Okay.
complaint. That'll be in our.
Okay. I tried, Wes. I tried. I had to ask. And you've already told us there were absolutely difficulties. It sounds like, so for those of you that don't know, Share Intel aggregates data and information from three sources: the DTC, the transfer agent, and a company called Broadridge, who aggregates information from the brokers directly. So, Wes, you did say that when it came to MMTLP, which always seems to be the exceptions, that the DTC and Broadridge dug in and would not share data. Correct.
No, no, they wouldn't.
Okay, thank you. Appreciate that. Let's talk about the transfer agents since I just mentioned they're part of the share and tell process. There's been a lot of speculation here in the MMTLP community and questioning as to whether the transfer agent, who is also the transformation agent for Meta, AST bought out, which is now Equinity, that they're working against NextBridge and its shareholders. We have seen some inconsistencies with two unregistered identifier numbers being used for our NextBridge shares. Do you have any sense that AST and Equinity are working against the best interest of Metamaterials, the company, or its shareholders?
I don't. You'd have to ask David Winger that, but I can tell
Okay.
you with certainty that many brokerage firms have created their own QSIP number internally
Yep.
to in essence keep track of shares that really don't exist. In my view,
Yeah.
I can't
Agreed.
I can't prove that at this point, but that's my very strong gut feeling. And so it's something I've never seen done before, where in essence to create fictitious shares from real shares, let's call it, a separate QSIPs being kept. This is my view. Okay.
Okay. Let me ask you a question. In with hold on just a second. With the data collected that you have seen, do you see any relevance to MMTOP? Is there cooperation with Meta and NextBridge? Can you share anything in that regard?
I think everybody is cooperative in that entire link.
Okay.
Uh, as you know, or the community knows, the flamethrower guys spent a considerable amount of money trying to pursue claims to really benefit everybody, because ultimately discovering what happened with MMTLP and what happened with Meta inures to everybody's benefit. It inures to Meta's benefit. It inures to MMTLP's shareholders' benefit, even if you sold shares. Which again, don't forget, in order to have standing as a plaintiff, as an individual plaintiff in a class action, you would have to have sold shares during the class action period. If you didn't sell shares, you don't have a claim under current law. Okay. So at the end, you may have a claim against your broker if they don't have your shares, but you don't have a claim for market manipulation under 10b-5, because 10b-5 is shares purchased or sold in connection with the manipulation. So you have to be a seller or a buyer. And in these cases, generally speaking, you have to be a seller. But absolutely, the Meta people are cooperating, at least as far as I know, with the MMTLP people, because they're derivative of each other. They're symbiotically attached. And certainly the main people at NextBridge, who are major shareholders, don't forget this, they
Yeah.
are major shareholders, big time, of Meta and MMTLP, who equally got screwed, and I know that for a fact. Okay,
Yeah.
so they are cooperating as much as possible. Each of them have duties to their own shareholders, so you have to separate that out. But there is a common interest in figuring out, as I would say, who is behind the curtain on the yellow brick road. Okay, who is back there? Okay, I have some great ideas, but it's all speculation at this point, other than
Sure.
what we know for certain, because there'll be defendants if we can get this thing filed. So, okay.
Well, speaking of that, I'm hoping I'm going to ask this question in a way that you can answer it, Wes. So recently, Devin Nunes, CEO of Trump Meeting Technology Group, put forth a list of potential market participants who have suspicious trading activity in DJT. Do you see any correlation between the firms on that list and those who potentially manipulated trading in MMAT, or even NWOB, Northwest Bio? Is there a correlation there from the data that you have? I'm not asking you who. I'm just
There,
asking if
there,
there's a
there,
correlation.
there certainly is some overlap. I can tell you that.
Okay.
Yes.
Well, there
Hmm.
you have it, guys. Dig in. So let me ask you, if Wes, if for any reason Meta does not end up moving forward for whatever reason, um, or even if they do move forward, is there an opportunity for shareholders to gain access to the data?
Well, certainly, if we're able to bring a class action and they become clients in that class action, then certainly typically the data can be shared with the clients. Although you need to understand these protective orders, which we're officers of the court, and so even though I try to be reasonably aggressive in litigation, we're always very ethical. Even though I was sanctioned once in my career by a court in one of these stock fraud cases back in like early 2000, because the court said we didn't have enough facts to sue that defendant. They were probably right, but who knows? Um, but getting one defendant wrong out of hundreds of defendants we've sued in this space is probably fair and reasonable.
Yeah,
Anyway,
it's bound to happen.
yeah,
So, but it's
look,
nice to know that.
as John O'Quinn said, he wore it as a badge of courage in honor of the working man. And okay, I wouldn't go that far, because I'm big on supporting what judges say. But my point is, protective orders have different categories of information. Some of it is attorney's eyes only, that the clients can't even see. So that's some of the stuff that's very proprietary, like the algos that are being used, for example, Those are attorney's eyes only, that kind of thing. So I can't answer that with certainty, but generally speaking, clients should be able to see what it is when information comes in. They would have to sign a document saying that they're subject to the protective order. But if it's attorney's eyes only, then no, they would not be able to see it. So it depends on which bucket that information resides in.
Okay, so let me ask this question. We, of course, as investors, have seen what appears to be the managed downfall of this company, quite honestly. So there's lots of questions about the data that was collected by Share Intel. Is that considered an asset of the company? And what happens if the company goes into bankruptcy? Can the shareholders get access to it? Can it be purchased?
Well, I'm not a bankruptcy lawyer, even though I've litigated in bankruptcy, including some of these cases like Sorrento or like Razor that we did in Delaware. That was like 10 years ago. Um, Basically, whatever assets the company has in a bankruptcy are always potentially up for purchase. Um, it's very complex though, because generally speaking, you cannot assign tort claims. You can assign contract claims, but you cannot assign tort claims. Generally speaking, so you'd have to assign the right to receive the proceeds, and then get a power of attorney coupled with an interest in order to purchase that out of bankruptcy, or the post confirmation estate of the bankrupt estate could bring the claim on their own, which means, and I've done many of these cases across the country, including against Signature Bank, who's now broke, so we're going against their insurance in Florida, not in a market manipulation case, but in a Ponzi scheme case. What happens is that post confirmation estate trustee is there really for the creditors, which generally is including the shareholders, because as we all know, in a bankruptcy, generally speaking, the shareholders are at the bottom of the barrel, right? So ultimately, in Sorrento, for example, the shareholders, as usual, didn't, in my recollection, didn't get anything out of the bankruptcy. But the post confirmation estate trustee, who's supporting us in getting this information in the 2004 examination, if we're successful in finding the documents we need, filing a claim, and ultimately monetizing that claim, then that money would go into the estate to pay creditors. And so that is a way by which the shareholders can benefit. Or I've seen other situations to where some very large shareholders who had a lot of money went in and purchased that claim out of bankruptcy, which we did in Razor in Delaware. So there's multiple ways the shareholders can benefit from that, depending upon their ability to purchase for cash the claim, or uh, alternatively, where the post confirmation estate brings the claim and then pays creditors that way, kind of like is going to happen, I hope, in this bank.
Okay, thanks, Wes. Really appreciate that. Appreciate your candor as well. So, one more question, Wes. Hang on just a second. When in the PR, it mentioned that this information from Sharon Tell will be shared with regulators. Do you know if Meta anticipates any civil enforcement actions from regulators, potential criminal referrals to law enforcement? Uh, are there any plans at this point, or are they just going straight for civil litigation?
I have no idea. I'm only
Okay,
responsible for the civil litigation piece.
okay.
And I say
You
that includes Alan Pollock, that includes other experts. I can't mention some of their names. That includes other law firms, because as I said, we've increased our bench to include other law firms in this litigation, most of which you can go find out by getting on Pacer in the cases we have in New York right now. So
Yeah. So, Wes, a little bit earlier, you mentioned arbitration. And of course, this has been kind of, just an insurmountable wall for retail, especially retail investors. Of course, we sign those brokerage agreements that, sign our lives away to arbitration. And you've seen in, for example, Richard Hoffman, who's a community member, he's spent enormous amounts of time and energy
yeah,
exposing the fallacies and the problems with arbitration. I'm not sure if you're familiar with the Bizzell law firm. They, of course, representing their client Intercoastal Waterways, V Trade Station in the Southern District of Florida. The plaintiff there is arguing that Trade Station violated various elements of their brokerage and lending agreements. Therefore, they're asking the court to render the agreement void, which includes the arbitration clause. Can you opine just for a few minutes about your general thoughts about arbitration? And do you think that this argument, if successful, will open the floodgates for a new way that investors can get restitution for fraud?
Well, first, let me say my understanding was that Mark Basile, who is a colleague and a great lawyer, is at least one of the firms that's handling that case. Is that not correct? I thought he was handling the trade station case.
Yeah,
You may,
no, he is. No, this is it is a shareholder lawsuit versus TradeStation. It is the Brazil law firm, correct?
well, Basile. I'm sorry. That when you said Bezel, that's what threw me.
Oh, I'm sorry,
It's Mark
Basile.
Basile. But anyway,
Basile.
at the end of the day, he's a great lawyer. I think it's a unique idea. What I like about that case, so to answer your question, so I don't seem to avoid it, I can't really answer the probability of success. I know, generally speaking, federal courts and state courts, but especially federal courts, honor. You know, if you walk, I have a saying: if you walk past the conference room where they're signing an arbitration agreement, you're subject to arbitration. So, I mean, that's how broad it's interpreted. So, breaking that cycle as a precedent in American jurisprudence, I think is going to be very difficult. What I think is a better idea that Mark Basile has pled is the RICO claims. He and I had talked about it years ago. Don't forget, under the federal statute, which is how we're bringing cases for the most part, because we want to just go to New York, and New York doesn't have any private cause of action state law claims we can bring. There is no RICO claims, okay, and New York doesn't have a state RICO statute either. But under federal law, the bad guys smartly got that excluded in the late 90s to where you can't bring a federal RICO claim in a market manipulation case. Not the case under state law. In fact, the Eagle Tech case, which we did years ago, brought racketeering claims against brokerage firms and others in Fort Lauderdale, Florida, in state court. We correspondingly did three cases in Atlanta, Georgia, including the Razor case. I'm sorry, including the Razor case and including the Taser gun case using Georgia racketeering. We brought another case in Utah, which is the one we lost on claim preclusion out of Georgia. Uh, um, so using state RICO, if you can get jurisdiction over the defendants, which my understanding is a train station is there in Florida, so that shouldn't be an issue, but I don't know. So I think the main thing to accomplish there is pursue those RICO claims and to seek information because ultimately finding out who trade station lent the shares to, finding out what they didn't deliver, either failure to deliver or failure to receive. Don't forget, there's every failure to deliver, there's failure to receive. Both of those parties, in my opinion, are liable and participated in the market manipulation scheme, which is another new theory we're going to be pursuing here in cases. So,
Awesome. Thanks for that, Wes. So, Wes, I want to shift gears a little bit and talk about state attorney generals. You're talking about state RICO claims and things like that. But one of our shareholders had an experience a couple of months ago. She was meeting with the SEC's ombudsman office in Washington, D.C. several weeks ago. In what was a 45-minute appointment, it turned into a 2-hour discussion. They were very pleasant, empathetic, complimentary of the efforts of what Greg McCabe calls the MMTLP Army, until the shareholder mentioned work with the attorney generals, at which point she observed a notable shift in their demeanor, the tone of their conversation. The SEC representative even went so far as to discourage our efforts with the state AGs by saying that Congress would no longer work with us if we worked with state attorney generals. She reached out to her senator, who promptly said that that was absolutely false. Wes, why are the regulators and the market participants afraid of state attorney generals?
well, let's just start by saying you're talking to Noah about the flood. Okay, so I where do I start? Let me just make this simpler. Okay, I want you to think about when big issues really occur on a national level. Who has solved them for the most part in litigation? Let's look at the issue with tobacco. Who was putting toxic substances allegedly in filters? Who solved that problem? Attorney generals. Who's trying to solve the problem with human trafficking? Attorney generals. Who's trying to solve the problem with opioids? Who stepped up? Attorney generals. So, is there a business plan? And I can't give specifics, so I'm just going to tell you, Vance, don't ask me the questions because I can't give the specifics. But all I can tell you is attorney generals can file suit in their jurisdiction. Why? Because as some of your listeners have posted, I've read some of the, I don't really get on Twitter, as you know, because I don't have time. But I noticed some of the posts in getting prepared for this call talk about the pension funds that have been robbed. So imagine attorney generals protecting the pension holders, the teachers' retirement funds, the policemen's retirement funds, the firemen's retirement funds, the other state workers' retirement funds. That's trillions of dollars, truly, that are getting pilfered by this process. I know that because I've already looked at and we've actually spent the money to look at key states that have state racketeering statutes. That's treble damages, boom, 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 right? Big stick. And that applies civilly and it applies criminally. And the predicates kind of cross over from civil to criminal. Imagine an attorney general bringing those cases in their jurisdiction and how that would get done, and also how much money that would bring to the states. Okay. Every state needs more money. Every attorney general wants to right wrongs, and frankly, they're not as politically compromised. All all people in politics at some level, I'm not going to say compromise, but they have constituents, they have people that support them, they have people that lobby them. Okay, that's just the way of life. But separating the lobbyists from right from wrong, my belief is that attorney generals are more inclined to do that, especially if they can monetize it and protect their people and use that as a platform. So, as my dad used to say, put that in your pipe and smoke it and think about it, because I'm going to submit to you that that may be a better way. I'm not going to sit here and bang on the SEC. Everybody knows where we are, in all the SEC amendments. You can still sell shares that you don't deliver. That's still happening. You can still lend shares 10 times. That's still happening. Market makers are still selling shares, in my opinion, that they don't deliver, and using the one exception left in Reg Show. I could go down the list. So who's more likely to do it? I believe AGs, but let's just say that movement is out of the gate, and where it goes, we'll have to see.
Fantastic. Wes, and I think it's part of a greater battle that we're seeing in this country between states' rights and federal rights. States are far more equipped to deal with the situations in their states. And when you're talking about some of these companies that are shorted to death in the states that they're domiciled in, it makes more sense that the AGs would protect that, not only for jobs, for tax revenue and everything like that. It just seems like that is where the battle really should be taking place.
I second that motion. All in favor, say aye. Aye.
Okay, then. Okay, Wes, we have about 13 minutes left. And so I wanted to take the opportunity. You and I opined about this in a call a couple weeks ago, and I wanted to give you the opportunity to talk about this. So it appears that there is a groundwork being laid to establish a collection of legal decisions that bring the various market participants to account of what may be considered financial terrorism. There seems to be a groundwork being laid to purge our markets. We see that with President Trump's Executive Order 13838, which references U.S. Code 50, dealing with unusual and extraordinary threats, declaring of national emergencies, exercising of presidential authorities. Of his 200 plus executive orders, that is one of the 70 that remain. We also see, like you talked about, with the various state RICO statutes. You mentioned earlier the Harrington case, where the courts, are determining that brokers can be held liable for the criminal acts of their clients. We also see from Public Accounting and the Oversight Board, Section 317, that states that auditors may be held liable for the illegal acts of their clients as well. We haven't talked yet about the Jarkizi case. Of course, that was argued in Florida, the Supreme Court, which challenges the civil enforcement actions of the regulators. And of course,
Yep.
we're awaiting a decision on that one now. Um, First of all, how do you see or anticipate SCOTUS ruling on the Jarkizi case?
Wow. Um, it's a
Sorry, that
great,
was a mouthful. I
great,
know, I know.
it's a great question. I guess it's a Fifth Amendment issue. At the end of the day, it would seem that to rule on our side of the V. That would be my guess. But just be clear about this. I'm not the scholar on our team. I'm the street fighter on our team. So I'm not the writer and I'm not the scholar. But my guess would be to err on the side of a right to a trial by jury. Okay, that's my guess. Um, I will tell you that, and I said this in the last call we had 6 months ago, or whatever, but it's even more so true now. There's more awareness in the attorney general community. There's more awareness in the regulatory community. There's certainly more awareness of Congress because the MMTLP community, frankly, for the most part. Although I will tell you, and I'm not going to sit here and bang anybody, but I'm not going to really spend any more time with Congress. I've got hundreds of hours in that, and at this point, I've got nothing. I got some letters that got sent out, but that's a letter. What's that going to do for us? So at the end of the day, I think it's up to us. I'm going to take us back to the Magna Carta and Runnymede and England, and the people are getting starved, which I would say is analogous to what's happening to the MMTLP community. And we have to continue to rise up and get everybody on our side of the V that we can. I will tell you that's increasing at a very rapid rate. I will also tell you, though, the bad news is that I believe this problem is so large that nobody's going to wave a magic wand over it. It's too large to make it all happen. How it gets resolved, I don't know, but it continues to get larger. And what the magnitude of it is such a large number that if I told you what I believe, you wouldn't even believe me. So at the end of the day, I think that is a problem. It's a problem for whoever wants to join the party to resolve this. But we have to start with everybody recognizing who's done this and the magnitude of the problem, and then we can figure out a way for restitution. Uh, that's in part going to be through the civil litigation route, which is our route. It's in part going to be by the government uh, people, probably at the AG level, in my view, that join us, or maybe even state securities commissioners that join us, because that's another entity that has authority to bring at least civil enforcement and refer it to attorney generals for criminal enforcement. Um, Ultimately, we have to keep plowing ahead. We have to be diligent. We have to do everything we can to move this forward, knowing that it's an absolutely hellacious battle. It is a hellacious battle. I can tell you just in one case, we're fighting 45 lawyers on the other side, and there's only 3 defendants in that case. Okay. So magnify that times 4 cases. That's why we've had to enlarge our team, and we're going to continue to enlarge our team. And I'll tell you why. Because more lawyers are seeing that this is wrong, and more lawyers are seeing that this is important to our country, and more lawyers are seeing that, frankly, they can make money at this. Ultimately, it's just a long haul. I'm hoping to speak soon. I've been invited to speak at Liberty University, and that university is all about making a difference in people's lives, including the lawyers at that law school. And so there's enough lawyers out there, believe it or not, that do care, that want to right wrongs. And so we have to enlarge that group and keep plugging. It's that simple. Being guaranteed of nothing, but at least know that we can sleep well at night, trying to be on the side of right and not the side of wrong. So
Yeah, absolutely. Wes, you mentioned the last space call we did with you. It was actually with you and the great Robert Shapiro, and I asked you and I asked you a question that elicited this response. And I apologize, I don't remember if it was you or Dr. Shapiro, but one of you said it's time we audit the DTC. Pulte, the billionaire Pulte recently said the same thing. And I warned him, I said, "Ooh, you said a very bad word. You're in trouble." Wes, are we ever going to see, as a means of cleaning up this system, are we ever going to see an audit of the DTC?
Well, let's include in it in its subsidiaries because if you look at the DTC, at least on the surface, their books balance on the share count, right? But when you get to the NSCC and then you count X clearing and you count other things, that's where it gets out of whack, right? This is my view. This is my opinion. Um, I don't know the answer to that. And you brought up accountants earlier. I want to tell you something I learned the hard way. I don't know that the accountants are vulnerable here, and I'll tell you why. The accountant's job is to audit the cash or capital on hand that the firm has in order to make good on the delivery of the shares on the day of the audit. The auditors, because we've deposed them over the years, do that job. What the auditor said off the record was, it's not my job to count shares. Okay. I see that they have a failure to deliver. I look at what it cost on that day to deliver the share. I make sure they have the capital in their account to be able to cover that share. That's their job. And so ultimately, the audit has to consist of not only the left side, which is the DTC, the NSCC, and affiliates, and that would include, now we're going to get really complex, that would include also going to Euroclear, that would include going to CDS in Canada, that would include going to Germany and other places. Because one of the things that nobody's figured out yet, even though the amount of trading stemming out of foreign nations is increased, how all those shares clear and all the avenues it goes through. You know, as we discussed on the last space call, the number of fails that deliver overseas is astronomical. Okay, astronomical. But who's behind it and all that? Nobody knows yet. But the point is, it's not just auditing the DTC. Respectfully, it's going to take auditing, the consolidated group, because don't forget, the DTC somehow is involved in CDS and somehow is involved in Euroclear and on and on and on. This is a global problem. It's not just a U.S. problem, and that global problem is getting larger. And I submit, I can't support this today, but it's my strong belief that the percentage of carnage that's being inflicted in from offshore venues or foreign nations is being larger. And I believe, again, speculation, that the main reason for that is it's harder to get that information. This is all about getting the information that is down about 9 layers that you have to peel back of the onion. Just an absolute gargantuous task, to be candid. And so, I don't know that we'll ever get to the bottom line, but again, you do it, in my case, one case at a time, while at the same time you pursue the regulators, you pursue everybody else that's supposed to be doing a job to protect investors. That's what they say, although they show up on the other side of the B in Sorrento, which blows my mind. Um, so that's what I think has to happen to make it, to
Okay.
truly expose it in totality.
Okay. Well, Wes, we have 4 minutes left, and I wanted to, first of all, thank you for your time. We got through most of the questions. I actually edited a little bit, but we got through most of them. So I really appreciate that. But I also want to say you've hinted at it many times, and you and I have spoken privately. I know that you have been here the whole time and that your fingerprints are on everything. And I wanted to thank you for the work that you're doing for the retail investor community and give you now 3 minutes to share any additional thoughts that you want to share with us before we go today.
Yeah, so I think the mission is for everybody to keep doing what they're doing, and anybody in the community. I know you've got one person I'm going to be talking to that really has critical information that they can actually support. I'd love to see that. Secondly, be patient. This is a slow process because of the cost of these cases. Getting it all done, frankly, is very complex. But I will tell you, everybody on the team, and again, the team is enlarged, is putting in a lot of time and effort into this. but the battle on the other side is unimaginable. It's truly unimaginable. And I've been blessed to do a lot of cases in my 45-year career. This by far is the toughest group of cases ever. Hence, we have to bring in a lot more people and frankly raise a lot more money through every means we can. So at the end of the day, because again, experts separate from what it costs our firm to do and other firms to do the work. There's tons of experts and consulting experts that are enormously expensive on these cases, all of whom can't be paid on a contingency. They have to be paid hourly. Otherwise, you'd be able to impeach their opinion. They can't be opining about how bad the defendants are if they get a piece of the pie, right? So they have to be paid hourly. So I encourage everybody to keep it up. Know that we are continuously making new law in these cases, whether it's making brokers liable, if we can prove reckless behavior, intentional conduct for their customers, that's huge. Whether it's exposing the direct market access machines, in Canada and other places, and that carnage there, whether it's exposing and figuring out all the different ways these trades are routed, which is mind-boggling. It's like a rat maze on steroids. Okay, once you really drill down, 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 down on it. So ultimately, our mission is to try to figure out a way to help everybody. The class action thing is going to be the latest thing we look at
The
to try
time
to help
is
shareholders
7
directly.
o'clock
Whether
p.m.
that works or not, I don't know. This isn't a typical class action like you file in a case where, Enron was worth 10 cents and you bought it for $25 as a purchaser, but the auditors lied and the board lied and it was only worth 10 cents. Our case is the opposite. You bought it, you sold it for, $10, but it was really worth 50 because of the manipulation. And of course, proving all that takes, an event study, it takes a regression analysis, it takes a lot of incredible hard work. And to do that analysis, you got to get all the records. And gathering the records when you have to go through 1, 2, 3, 4, 5, 6 brokers to get, to find one share, and then multiply that times, hundreds of millions of shares, you can imagine the document review is mind-boggling, mind-boggling. So, so ultimately, I can say we're still hot on the trail for now. But again, each day we take a day at a time because you just have to be relentless. We're going to try to do what we can for everyone, but again, how that pans out, is left to be, determined. So I honor each one of you for staying on this path. This is truly Runnymede. Go read about the Magna Carta and Runnymede. This is Runnymede stuff. Okay, this is
Well,
it, as a good friend of mine said. It's either the courts or it's the streets. Okay, and so this is going to get resolved one way or another because this truly has enormously damaged Americans, hundreds of trillions of dollars, in my view.
yeah.
That's my view. So we have to keep rising up. We have to do what we can, and anybody that doesn't do that, frankly, is a traitor. Okay, so that's the way I see it.
Well, Wes, I've said this many times to the MMTLP community. They've heard it over and over and over again. I'm going to say it to you. It's the right people in the right time for the right fight. And we're so grateful that you are one of our people. So they messed with the wrong ticker this time. And we're going to continue that fight. And we appreciate you doing the same. So, Wes, thank you again for your time. We are 2 minutes over, but I think for our record, we did really good. So thank you. And I look
Well,
forward to.
thank you, and go forward, and we're each going to do our best. Okay.
Yep, absolutely. Thank you, Wes.
Bye
Guys,
bye.
we're going to go ahead and close the space to preserve the recording. Busy is going to open up the after party so we can talk about Wes while he's gone, and we'll continue the conversation there. So, a lot of information dropped today. It's going to take us a bit to cycle through it, but we'd love to have your thoughts. So, again, thank you everyone for coming, and we'll let you know when we do this again. Have a good one, guys.
right, guys. Great job, Savvy.